U.S. Justice Department obtained a court order directing Twitter to turn over information about the accounts of activists with ties to WikiLeaks. This includes not only Julian Assange himself, but also Brigitte Jonter, a member of the Icelandic parliament, Rob Gondry, a Dutch hacker, and Jacob Appelbaum, a former WikiLeaks volunteer and U.S. citizen. Now, the information the government wants includes all connection records and session times, IP addresses used to access Twitter, email and residential addresses, plus billing records and details of bank accounts and credit cards. That is quite a broad swoop for information, to say the least. But perhaps the most interesting bit about this story is that the only reason we even know about this request, the only reason the news became public, is because Twitter fought the U.S. government. They were sent a secret court order known as a national security letter, which comes equipped with a gag order, but challenged that secrecy in court. And they won the right to inform the people whose records the government was seeking. So, thank you, Twitter. Here to discuss it with me is Julian Sanchez, research fellow at the Cato Institute and D.C.-based writer and journalist. Julian, thanks so much for coming back on the show.
Anytime.
Now, I want to first talk about this specific type of court order, these national security letters. They're authorized under the Patriot Act, and the government apparently receives, is that wrong, under the Patriot Act?
What was used here was what's called a 2703D order. It's part of the Stored Communications Act, which is itself part of the Electronic Communications Privacy Act, which is a law authorized in 1986. With very few changes since then. It was written to govern email and other kinds of electronic communications and electronic storage. It hasn't really been substantially updated since then, with some minor tweaks again in the Patriot Act. But services like Twitter, I think, are showing just how badly outdated something written for the state of online technology in 1986 is when you try and apply it in 2010.
What they're telling us now, though, is that, they might send out up to 50,000 of these requests a year, and they all come equipped with this gag order. I mean,
those are national security letters.
Yeah, this is the national security letter. So, I would call that an attempt to silence people, would you not, if everything is equipped with a gag order?
Yeah, and of course, these orders also, 2703D orders, are routinely issued attached to gag orders of their own, delayed notice, or often in other cases they're bundled together with what's called a pen register order, which is a different kind of electronic surveillance order, and those tend to also go under seal until they're sort of further released. So that's another way that the extent of this kind of monitoring can be concealed. And unlike wiretaps, when the government does an ordinary phone wiretap, that ultimately has to be reported. So at least at the end of the year, you get a kind of tally of what states are issuing these, how many, for what kind of investigations. But these D orders, there's no such federal reporting requirement. So really, Americans have no sense at all of just how frequently the government is going to internet service providers, Google, Facebook, other kinds of services like that often store for us the most sensitive kind of information to get records.
Okay, but so just to clarify, this D order and the national security letters, these are different things,
those are
right?
Different
so
things.
I got these mixed up.
A national security letter doesn't even require a judge. A national security letter is basically something the FBI issues on their own recognizance, saying they pinky swear that somehow what they're looking for is legitimate.
Well, that should make us feel a whole lot better.
This is a little better. A D order, they do have to go to a judge. But all they have to show the judge is specific facts establishing that the information they're seeking is relevant to an authorized investigation. And that's a lot lower standard than probable cause, which is what the Fourth Amendment requires traditionally for a full-fledged search warrant. So if they want to search your house, probable cause, that's a pretty high standard. Relevance is a lot less. It basically means we have some reason to think this would be helpful. It doesn't necessarily mean that they have any evidence that the people whose information they're getting are guilty of a crime.
Well, what's so interesting to me, too, is that Twitter here, they had the option of just letting the government have its way, but they didn't do that. They decided to fight in order to be able to disclose to these people who are under investigation the fact that the government is seeking their records. Are they becoming a new, advocate here for privacy? I mean, could we imagine Facebook or Google doing the same thing? Because I would think they probably have a lot more personal information on clients than Twitter does.
Well, ironically, it's Google and Facebook that are members of the Digital Due Process Coalition and the Global Network Initiative, which are groups of online companies that have sort of vowed to fight for greater privacy and greater freedom online. I don't think Twitter is a member of those, but they're the ones who stepped up here. I think, again, maybe ironically, it's because they don't have a lot of private and sensitive information. There are private messages on Twitter, but mostly Twitter is for sharing things publicly, which means and this is a guess, but I'm suspecting that they don't get nearly the volume of requests that companies like Facebook and Google do, which means maybe they can afford, when they do get such a request, to have a lawyer spend hours fighting for the right to make it public for their users.
Well, this
companies
is,
like Google and
kind of
Facebook,
a high-profile case,
right,
also, you could say. But does Twitter have these bank account information,
No.
bank account information, credit card information, everything that the government is seeking from them here?
No, that's just boilerplate from the 2703D statute. It looks like what they've done is just cut and pasted into the order essentially everything that they're entitled under the statute to ask for, and essentially letting the provider decide what they have that's in compliance. I mean, the rule of thumb they tend to follow is ask for everything we can get, let the provider disclose, and the provider's incentive, usually these are secret orders, and so their incentive is always disclose as much as possible, because if we don't disclose enough, well, the government will certainly come after us, but it's a secret order, so if we, are really protective of our users' privacy, they're probably never going to know about it, so why bother?
What's the most dangerous thing that they can actually get here on Julian Assange, on this member of the Icelandic parliament, when it comes to their Twitter accounts, though?
From Twitter, under this order, it's not clear that much. What they may be trying to get is a social graph. That is, if you can sort of track who is communicating with whom privately, you can get a sense of what the social network around Twitter looks like. Also, those IP addresses may be useful because if you have, let's say, an anonymous account, who are the different people who have authority to post to the WikiLeaks account? Are there people working with WikiLeaks we haven't identified yet? You get that list of IP logs and session times. You may be able to use that to trace it back to an original user. You may also have an interest in knowing where a particular user was at a particular time. That's something else an IP address can be useful for.
So another example of them, they're obviously very, trying very hard to build this case, build a criminal investigation against Julian Assange and WikiLeaks here. Is Twitter going to help them do it? I don't know. We'll see. Julian, thanks so much for being here.
Anytime.
For more WikiLeaks news, visit wikileaksnews.org.